Well, I wanted to thank everyone for joining us today. My name is Samantha Poole. I'm with the New Hampshire Lodging and Restaurant Association. This is a review of federal and state youth labor employment laws with attorney Jim Reidy from Sheehan Phinney. We're really lucky to have Jim here with us. He's a great asset to really explain these concepts. So a little housekeeping is we're going to do all question and answers at the end. If you want to put your question and answers in either the chat or the Q&A boxes, I'll be sure to read them and we can go through them after the presentation. So now I'm going to turn it over to you, Jim, and further introduce yourself.
Oh, great, thanks. Well, good morning, everyone. Thanks for taking time out of your busy schedules to be here today. Again, as Samantha said, it's actually my pleasure to be here. I do a lot of work with lodging and restaurant businesses, and I'm certainly familiar with this topic. I've been practicing in the area of labor and employment law for go on 34 years at this point, and all manner of issues that we've addressed. In fact, in recent months, we've done stuff on tip pooling and tip sharing for you folks, and we've also done one on discrimination. A big issue coming into the summer, of course, seasonal workers, when you have younger people in the workplace and even younger supervisors, but not necessarily younger supervisors, it is a hotbed for potential harassment and misconduct in the workplace. And that's what we talked about last month. EEOC, the U.S. Equal Employment Opportunity Commission, is focusing on youth employment again this year, considering them to be a vulnerable population. And in that regard, that's why we're talking about that today, too, because you're coming into the very busy hiring season, April through June, the peak in July for youth employment. It used to be kids, of course, would stay until September, but colleges and secondary schools moved up their start dates into August. So you have a lot of kids leaving in August when they used to stay through Labor Day. But still, it's an important time. I was saying to Samantha before we started the program that this is projected to be another big year for youth employment, available jobs and very attractive wages. We, of course, are all suffering with post-COVID issues, economic issues, and one of the benefits for those seeking work is wage inflation because of the competition for jobs. So we're going to talk about a number of things today. The first thing we're going to talk about is some youth employment statistics as we come into the hiring season. And then just a comparison of federal and state youth employment laws. I do a quick summary of the federal laws, but a comparison of the two. And the reason why I'm doing a comparison of the two, meaning specifically federal and New Hampshire, is that when there is a conflict of laws, you typically look at who provides, which law provides the greater protection. You also look to see if one set of laws actually is intended to occupy the entire field, meaning no other law can be in that place. That is the law. Now, you rarely find that here. In fact, you'll find in youth employment, it's the more protective activities. And then, so we're going to focus on the New Hampshire youth employment laws, which are not that different from Massachusetts, Vermont, or Maine. And then we're going to talk about some New Hampshire Department of Labor enforcement activities and what's involved with that. Now, I will tell you that I've had a lot of experience in this regard. Again, as a management side labor and employment lawyer, the youth employment violations are one where the Department of Labor will rarely compromise because, again, their job is to protect youth and they're considered on a federal and state level to be vulnerable population. I often joke that my kids, when they would start a job, I've got 4 kids, and when they would start a summer job, whether it was working at a camp, at a restaurant, lifeguarding, whatever it was, I'd say, so that's great. You got a job for the summer. Terrific. What are you making? I don't know. And or working, at one point I said to my daughter, how many hours have you worked? And she said, like 70. I said, you're kidding, 70 hours in a week? She's like, no, 2. It's sort of a different, getting used to what it's like to work in a workplace environment coming from school. Again, you're talking about kids principally from ages 15 to 17. And we'll talk a little bit about that, but so getting used to that and also understanding that they have there are some protections and some rights that they have. And we'll talk about some recommended best practices going forward. And what I'm going to draw upon there is that the experiences that we've had with the Department of Labor and enforcing youth employment, the Department of Labor is very, very specific. They're very technical. And because again, their objective is to protect the youth. And so they focus and bend very little and compromise virtually not at all with regard to the standards under federal and state law. So some general statistics to start with. In July of 22, the U.S. Bureau of Labor Statistics reported that 55% of young people, meaning those 16 to 24, and our target numbers are really 15 to 17, were employed in the U.S. And that was an increase from 2021, but the 2022 number was lower than pre-pandemic. But you look at it still, that's a pretty significant number of people. And most of you probably have vacant positions, whether they're year-round or seasonal, and you're looking to fill those. And so you're going to be competing with others, certainly. And of course, I mentioned earlier that the month of July is typically the peak season for youth employment. And the unemployment rate for youth in July of 2022 was down from 2021. It was 8.5%. And again, different from July of 2019, which was 9.1%. So what are we pointing to there? We're saying that in July of 22, more youth were working than not. And I think we're going to find that again. What they said last year was 2022 was the best year in almost 40 years for youth to be working. And we're talking about high school and college age principally, because of the available jobs and because of the level of wages available. They're predicting 23 could be the same. Now, while that's a little bit different, meaning it could be another big year, while it's a little bit different, you may have been hearing that industries are now starting to lay off. And I'm not talking about seasonal lodging or restaurant. I'm talking about other industries are laying off because of other pressures in the economy. What that means is there's a contraction. And so some of the jobs that kids principally in high school, later high school and the college years, and perhaps just post-college would be getting now, they may not be available as much as they were last year because of a contraction in the economy. That being said, for seasonal businesses, it's the Oklahoma Sooners rush here for filling those jobs and lots of available positions and lots of students. And by the way, I want to mention one thing. One of the things that we've had here sponsor at the firm and have done since the mid-90s is a listserv called New Hampshire LaborNet, NHLABORNET, New Hampshire LaborNet, and you can find it on our website. The reason why I mention that is it's an HR and business owner listserv, a discussion page. But one of the things that we permit on that is posting available jobs. So in addition to your local newspaper, online, your website, LinkedIn, or wherever you might post, or at schools and so on, you can certainly post for free on New Hampshire LaborNet. So if you go to our website, look under links for and resources for New Hampshire LaborNet, sign up, it's free, and it's a great way to post available positions. More statistics. The youth labor force working or actively looking grows sharply between April and July. And I mentioned that just a second ago. And during those months, that's when you get your high school and college students looking for the jobs. And you look at those numbers in July in the summer of 22 and how our labor force grew by 2.6 million, or almost 13%. That's amazing growth. Now, we're looking at jobless numbers coming out. We're looking at labor participation numbers, but youth employment is still sort of a separate subset. And it talks about 5.1 million of the employed, which is again 16 to 24-year-old workers, were employed in leisure and hospitality industry. So a pretty significant number of those were working in your industry. And that's your sweet spot. That's who you're looking for. I mentioned before protective statutes, and that's kind of important because it's not just wage and hour. So under the Fair Labor Standards Act, which is wage and hour, but it also deals with specifically the subset of youth employment. There is also protections, child labor protections, and age protections under Title VII of the Civil Rights Act of 1964, amended in 1991. The Americans with Disabilities Act would apply, if you've got 20 or more employees, would apply to youth who may be disabled with a physical or mental disability. OSHA Occupational Safety and Health Administration would certainly apply, removing hazards from the workplace, and the U.S. Department of Labor Office of Child Labor, which is under the FLSA, deals with forced labor, human trafficking, and they do research. There's awareness programs, they fund various projects and so on. And it's global, but they also focus in the U.S. market or a tangential market to the U.S. where child labor may be used to benefit U.S. employers. So our focus today, of course, is domestic in the U.S. and principally in New England, and even further down, drilling down to New Hampshire for purposes of youth employment. And some of the things, again, that you need to be aware of if you're not, and I'll give you some practice tips based upon my experience with our friends at the federal and state Department of Labor with regard to youth employment. So I talked about unemployment a second ago. Currently in the US, unemployment is 3.5%. And for those economic majors or minors out there, you know that full employment is 4%. So we're below full employment, which means that you've got more people working than the government had factored into its equation. In New Hampshire, the number is actually 2.7%. And in some districts, some counties rather, the number is actually lower than that. So in other words, it's a thin labor pool, and I'm not telling you anything you otherwise don't know. The challenging part of that, in addition to those numbers, is the current labor participation rate is 62.5%. Now, you want labor participation to be in the upper 60s to even low 70s if at all possible. We're not finding that. So what that suggests is the government is saying that either people aren't working, they're on disability, they're on unemployment, or they are working under the table or in non-traditional industries where they've not necessarily reported out their income. So with all of this, again, the demand for youth workers is high, and employers need to hire for both these seasonal positions, but again, some other positions, full-time and non-seasonal positions, you're in competition with them because those positions remain unfilled. So the labor pool is there and they're ready to work. You just need to proceed with caution. And why is that? Well, because again, the federal and state laws are meant to protect youth workers and not taking advantage of them, certainly, and making certain they work in a safe workplace and that they are paid the wage that they are due. So the basics, what are we talking about? Any employee under age 18 is considered to be a minor and covered by most youth employment laws. And most states, and our firm represents a wide variety of businesses within New England and beyond, and most states have their own rules about employing youth workers. Some states have separate minimum wage requirements. And there's a student learner wage, there's a sub-minimum wage for disabled workers, and of course, you have a sub-minimum wage for tipped employees. And when, I mentioned this a few minutes ago, when federal and state rules are different, the rules that provide more protection effectively govern. So that's something to look at. And we'll talk about, again, the comparisons between the federal and New Hampshire youth employment laws and how they differ and who offers more protection. Here's how they're organized, and it's pretty straightforward. And I'll tell you, most laws, most employment laws are based on one of two things: age of the employees or the number of employers that you have as an employer, number of employees that you have as an employer. What do I mean by that? So just to talk about that very quickly, because for wage and hour purposes, all you need is one employee for all the wage and hour laws to apply to you, one or two employees, depending upon federal or state. And certainly you will. So all the wage and hour laws apply. The same is true with workers' comp. The same is true with unemployment. All you need is one or two employees and you're covered. Beyond that, the thresholds are 6 for federal employment discrimination, 6 for state employment discrimination, rather, 15 for federal federal employment discrimination, 20 for federal age discrimination, 50 for the FMLA, and so on and so on and so on. But the ages matter when you're talking about youth employment. 16 to 17-year-olds, they group together. 14 and 15-year-olds group together, and under age 14. And you'll even see some that is 12 and under. But I think your focus should be, again, 14, 15 up to 17. And what matters is the age of the employee when he or she is hired and commences work. Why do I mention that? Well, if a kid is, say, 17 when you hire them in April, but they don't commence work till June and they turn 18, then the youth employment laws don't apply, because once they commence work, they're 18 and they're not considered to be a youth anymore. It also matters on the other end of the spectrum when you hire someone, say they are 13 when you hire them, and I actually don't like that number. I'd say 14 when you hire them, but they're 15 when they commence work, and then you would focus on that as well. Why do we mention that? Because there's a breakout between 14 and 15-year-olds and 16 and 17-year-olds for purposes of the paperwork that has to be in place when they are hired. FLSA, that's the federal wage and hour law. The Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping, youth employment standards affecting employees in the private sector, as well as federal, state, and local governments. And again, my audience today, we're talking about private sector employment. The child labor provisions of the FLSA were enacted to ensure young people that they don't work in situations where it may jeopardize their health and well-being or educational opportunities. And generally, they're the same minimum wage requirements and overtime protections as older, meaning 18 and above. Now, when was this adopted? If you go back in the Wayback Machine, back to the 1930s, there was no such thing. In fact, if you look at most of the laws that we deal with in the workplace, most of them did not exist before the 1960s. But go back to the 1930s. That's when organized labor came into place, but also, I mean, the labor unions under the National Labor Relations Act, but you also had protections for women and children. Why? Well, I'm here in Manchester, New Hampshire today, and you look out over the mills, those mills were populated with young people and women working in the textile mills. Those sometimes were very hazardous environments, and there was virtually no law that protected them with regard to their health, their safety, their wages. So the FLSA was adopted in the 1930s to basically add these things in. Again, minimum wage, overtime pay, youth employment standards, and workplace safety issues. And then you project forward to other things that have come along. I've been in private practice since the late 80s, and the number of laws that have been adopted since then, and we're seeing more and more all the time, it's mind-boggling, because again, while in the 60s there were some things adopted, it really was late 70s into the 80s that you saw this explosion of workplace laws, and that continues. So here's our comparison between the federal and the state. And of course, in your workplaces, you're going to have those required posters up. The youth employment posters, the discrimination posters, the minimum wage posters, workplace safety, and so on and so on and so on. You know those either getting through your payroll service, you're getting them online. Make sure they're up to date, and they change all the time, and they're free. While you may get them laminated from a payroll service, you can also just get them online and just print them out and post them on your common bulletin board, and make sure that's visible to all employees. So on the federal standard under the FLSA, you've got children under age 14 cannot work and except in certain limited occupations. And that's a good thing. Again, it's meant to protect children, including delivering newspapers, something I did for many years when I was a kid, babysitting on a casual basis, meaning not an established business, and casual is actually defined in the statute, performing in radio, television, movie, and theatrical productions. And what I get from that was the effect of the lobby that wanted child actors and that they could actually work under age 14, but there are certain laws that certainly apply to them as well. And working in their parents, for their parents' solely owned business. Not just their parents running a business, but their parents have to own the business. Now switch over to the other side of the equation for New Hampshire. No youth under 12 may be employed or permitted to work except for the parents, grandparents, or a guardian at work that is defined in the chapter as casual work or door-to-door delivery of newspapers. So you see the standard for New Hampshire is actually lower. Does that provide greater protection? No, the greater protection in that case is actually the feds, because it said, but it's authorizing employees as young as 12 to work. However, it's very limited as to what they can do. And I would venture a guess, by the way, going back to that slide, none of you are hiring 12-year-olds, 13-year-olds to work in your businesses. And if they are, it has to be truly casual work. And so, and under the federal standard, it's, the work that they're doing. So it can't be hazardous. It can't be something, and I'll talk about what hazardous means. But chances are you're talking about hiring at least 14, probably closer to 15, up to 17. Under the federal standard, youth 14 to 15 may work outside of school hours in various jobs. And those jobs are everything from, and I'm not sure what office clerking would be for a 14 or 15-year-old, acting as a cashier. You rarely see that too, except maybe in fast food restaurants. Tutoring, computer programming. I smile when I look at that, thinking of my kids as they roll their eyes when, mom or dad are having a hard time with whether a laptop or a smartphone. Grocery bagging, very common. Gasoline pumping, I think maybe you'd only see that in New Jersey. And delivery work, but excluding, and this is important, manufacturing, mining, and other hazardous positions. And I'll define what that is. And that's a big one, by the way. If it's a work environment, not just the hazardous position, but a hazardous work environment, that's something the Department of Labor comes down very, very seriously on. Switch over to New Hampshire. No youth is under 16. Under 16 now shall work in dangerous areas in manufacturing, construction, mining, or quarrying occupation, or in the woods, or in logging. Makes good sense. So you look at the differences there. Now you're really talking about, while it's not really a conflict, because they say the same thing with regard to hazardous environments. Federal talks about 14 and 15 working in certain jobs. New Hampshire talks about anything under 16. But that being said, if you look at the jobs, they're really not in conflict. No youth under 16 shall, this is again New Hampshire, be permitted to work earlier than 7 a.m. or later than 9 p.m. no more than 3 days per 3 hours per day rather on school days, and 23 hours per week during the school weeks, except in non-school days. And this is a statute needs to be updated for purposes of being general neutral. He may be employed 8 hours per day and during vacations 48 hours per week. Upon application, an employer who employs youth under 16 years of age in agricultural work, which doesn't necessarily apply to you folks, it's a petition you have to make to the commissioner at the Department of Labor. You see some of that in some industries, in some parts of New Hampshire, but it's not that common, and certainly not common to you folks. Back to the feds, they cannot, meaning we're talking about 14 and 15-year-olds cannot work more than 3 hours during a school day. Now it's the same as basically as New Hampshire, 18 hours in a school week, 8 hours on a non-school day, 40 hours. But you see it's more liberal on the New Hampshire side. I don't know that you're going to have kids working 48 hours per week and so on. Likely it would be 40 or less. In New Hampshire, the employer's pre-designated work week should be during school session is 5 days. No youth 16 or 17 years who are enrolled in school should work more than 35 hours during a work week. So I think it's important to focus on, again, the ages of the kids and whether or not it's school weeks or vacation weeks for purposes of the hours they work. And again, I'm going to talk about that. And I've got a very useful, and it sounds very simple approach to that to avoid issues with our friends at the Department of Labor. Very interesting on this one. Under the federal, no restrictions on the hours of work for 16 and 17-year-olds. However, in New Hampshire, no youth 16 or 17 years of age who's duly enrolled in a school, and of course, many of them would be, shall work more than 6 consecutive days or 48 hours in any 1 week during school vacations, including summer vacation. And it defines what summer vacation is. And it talks about an exception to that as well. But that's you're looking at the New Hampshire standard then being the one to look at for purposes of restriction on hours. And again, if that's the standard we're talking about, let me go back here. If that's the standard we're talking about this summer, that's the one to focus on. No youth 16 or 17 years old enrolled in school shall work more than 6 consecutive days or 48 hours in any week during a school vacation, including summer vacation. On the feds, there's no youth certificate required. However, as you know, in New Hampshire, it is absolutely required. And you've got 2 different types of youth certificates, and we'll talk about those in a second. I'll provide you with a sample form. No youth 16 or 17 in New Hampshire, except a youth 16 or 17 years who's graduated from high school or obtained a GED, shall be employed by an employer unless the employer first obtains and maintains on file a signed written document from the youth's parent or legal guardian permitting the youth's work. That is very important. Now, again, that's 16 or 17-year-old. When you have someone that's between 14, 15-year-olds, there's a separate form that has to be on file too. I want to talk about that because the law is a little bit different in that regard, and the timing is a little bit different, but I'm going to have, I believe, is a practical rule of thumb to go by for purposes of having that paperwork in place. It is critical. I think the most critical things to focus on here are whether you can hire them, at what age, what work environment they can work in, the hours of work that they can work during school and during non-school weeks, and the paperwork that is required before they commence work. And it must be completed. And we rush to get that paperwork done. That paperwork is as important as the hours of work and the type of work environment that they're working in. So let's go to New Hampshire here and focus on what the requirements are, because that's largely what you're going to be dealing with. For purposes of the policy statement, New Hampshire says it declares that this policy is stated to foster employment of young people, at the same time provide them with the safeguards necessary by their age. And again, the determining factor is by age, and again, types of workplaces. Let's go with one of the first provisions in the youth employment law. No youth shall be employed or permitted to work in a hazardous occupation. And I would add to that hazardous work area, except in apprenticeship, vocational, rehab, or training program approved by the Commissioner of the Department of Labor. Even then, here's how you define anyone in New Hampshire under age 18 cannot work in manufacturing or storing of explosives. Well, that's a good thing. Motor vehicle driving or being an outside helper. You may have a kid who has a license at age 15 and a half or 16, but they can't be driving until they're over 18 for your business. Coal mining or mining of any sort, I don't think that that's an issue here in New Hampshire, but logging and sawmilling could be. Power-driven woodworking machines, that's important in a shop. Exposure to radioactive substances, that might be in a laboratory or even in a medical or dental practice. Power-driven metal forming, punching or shearing machines. Again, we're talking manufacturing, light or heavy manufacturing there. Slaughtering or meat packing or rendering. I will tell you that back in the day, one of my brothers actually worked in one of those environments. And I would venture a guess, and it was not in New Hampshire, I would venture a guess he was not 18 at the time. Power-driven baking machines, power-driven paper product machines, manufacturing of brick, tile, or those things that are in a kiln. Power-driven circular saws, band saws, or shears, wrecking or demolition, roofing, excavation. And I'll tell you, I've had a couple of cases involving ski areas where 15-year-olds were not allowed to assist, and even though they were teaching skiing, were not allowed to assist kids on the chairlift and lower the non-manual bar, even though I argued, and I think I argued successfully, that it was not motorized. It was a manual bar that would come down to protect, the 5 and 6-year-olds as they went up the ski lift. Also, the motorized magic carpet that kids would go on the bunny hill, and also helping kids on and off of the the slides that they're on at certain ski areas. Our friends at the U.S. Department of Labor had a problem with that under their regulations. I think being more practical about the application of these things, it was kind of important, and I think we were able to educate the inspector in that regard. But you'll see these are the hazardous conditions that youth under age 18 may not work in, and that's important. And that would be not only a violation, but an expensive violation if you had kids working in those areas and performing those tasks. So let's go back to more general prohibitions under New Hampshire law. No youth under age 16, meaning ages 12 to 15. And I would argue, again, you're not going to have 12 and 13-year-olds principally working for you, maybe not even 14-year-olds, shall be employed or permitted to work except with a certificate filled out by parents, grandparents, or guardian, and school or the school system. And they cannot work except as defined in the statute. It talks about farm labor as well. Again, that's not going to be a factor for you folks, but the youth certificate it's a youth certificate required for any youth 12 to 15 years old, must be on file with the employers. Now, here's what I was talking about earlier. The statute says in the employer's place of business within 3 business days of the first day of employment. I would argue, do not do that. Have it on file before the kid starts working for you. I'm surprised that it's a 3-day rule, and you'll see why, because there's another requirement that says it must be in place before the kid commences work. Very important. That's for older workers. You would imagine there'd be greater protection for younger workers. So 12 to 15-year-olds, they must have, it's filled out by the school, and it's filled out by the parent or the parents or guardians, and it's provided to the employer. So this is what it looks like. It's the name of the employer ID. This is found on the Department of Labor website, by the way. The name of the youth, the job description, meaning what are they going to be doing? It's going to have the age, date of birth, and gender. And it's issued by either the parents or by the school department, and what school district that is. And it's provided to the employer, and the employer files that. Now let's see. What happens is the certificates are issued by principals of schools or persons authorized by them, or a parent or legal guardian, after the determination of a satisfactory level of academic performance by the student, meaning it has to be approved by the school, and then the parent or guardian signs it. If the student does not continue to meet satisfactory academic performance after the issuance of the certificate, the principal of the school or persons authorized by them or the parent or the guardian may revoke the certificate. In the event that the certificate is revoked, the notification of the revocation is made to the parent or legal guardian, the employer of the student, and the Department of Labor within 48 hours of the revocation. In the event of the parent or guardian revokes the certificate, the notification of revocation is made to the employer of the student and the Department of Labor within 48 hours. So again, if you go back to the standard there, it's to protect kids in certain working environments, not only their wage, but also the health and well-being, but also their academic performance as well. You don't want them working so it's a detriment to their advancement in education. So again, here's the standard. The employer completes the employer's request for child labor form, which is on the Department of Labor website, gives it to the minor. The youth has the school or parent or legal guardian complete and sign the certificate, and the youth returns it to the employer, and a copy is provided to our friends at the Department of Labor. Again, I want to go back to that. That should be in place, even though the statute says within 3 days of the commencement of employment. My recommendation is have that in place before the kid starts working. And what does start working to? If you have a seasonal business where they go through some sort of orientation and training that is needed for the job, that's considered to be employment. So I would have that certificate in place at that point, and further, to the extent that orientation and training is required. Remember, our friends at the Department of Labor call that compensable time, meaning you have to pay the kid for attending that. So that's those, watch out for those. Rules for 16 and 17-year-olds, and that's your sweet spot. That's where you're going to be hiring a lot of these kids. that are covered by youth employment laws. They don't need to have that other certificate that we just talked about, but they do need to provide the employer with a signed permission form from a parent or legal guardian. So now it's not the school anymore, it's the parent or legal guardian. While the school is important for purposes of restricting the number of hours that they can work, a 16 to 17-year-old during school years, school weeks, rather, school days and school vacations. Now what you need for a 16 to 17-year-old, again, 16 to 17 at the time you hire them, is a parental certificate. And that statute says it must be held by the employer, signed, completed, and kept by the employer before the youth commences work. So I would say those standards for both of those forms need to be in place. And this is what this says. It's a parental permission form for youth age 16 or 17. So remember, the first form is for 12 to 15, and that covers both the parent form and also the school. This one is just for the youth 16 to 17, and it's the youth's name, date of birth, address, and the name of the parent or legal guardian signing on behalf of the youth. And identifies the name of the employer, the location of the employer, and the description of the work, dated and signed by the parent or legal guardian. This, again, I'm going to say it again, must be in place. And if you're just hurried to have a lot of people and you get something that's, your hiring manager is just completing as much paperwork as possible, getting stuff online, getting ready to start, make sure this is completed and kept on file. You must have a copy on file in the event that the Department of Labor comes in to do an inspection, and it must be completed, meaning dated and signed, and all the other information, like I said, is included. So youth under 16, I'm going to go back to the days and times of work. When in school, when in session, minors and anyone under 18 is deemed to be a minor, may only work no more than 3 hours on a school day, Monday through Friday, and 8 hours on non-school days. No more than 18 hours in a school week, no more than 40 hours in a non-school week. And it talks about the hours of work in which they're restricted, except from June 1 to Labor Day, when hours can be extended to 9 p.m. Youth at least 14 years of age may now be employed, this is new, in lounge areas and in areas in addition to a dining area in a restaurant, principally, may clean tables and remove empty containers and glasses, as well as assisted stocking. That's a relatively new change here in New Hampshire. Days and hours of work. So time restrictions for 16 and 17-year-olds in New Hampshire are determined by school days and school vacations. Again, when in school, that talks about the days a week, depending upon what, if it's a, depending upon the number of school days we're talking about, that's the restriction. And then when you're talking about school and summer vacations, the hours of work for 16 to 17-year-olds. This question comes up all the time. If a student is homeschooled, are they considered duly enrolled in a school? And if so, do the hours apply? And the answer is yes. The Department of Labor takes the position that if they're homeschooled, they're considered to be enrolled in school, and the same hours apply as if they were attending the school district. So if the school district is 4 days, if it's 5 days, the school district that homeschooler is in, those are the standards that would apply for that youth. New Hampshire's repealed the prohibition on youth night work for 16 and 17-year-olds. Now there's no law limiting the number of evening hours, as long as the hours worked, and this is important, still don't exceed the maximum number of hours they can work in a school and non-school week. I talked about the penalties from our friends at the Department of Labor, and these are the penalties. While it is criminal, we'll rarely see that, where whoever employs a youth or permits a youth to work in violation of the statute, or any grandparent, parent, or guardian who allows a child to be employed to work, shall be guilty of a misdemeanor, guilty of a felony in some instances. I don't focus on that because I can tell you in my career, I've never seen that. What I do see, however, is the civil penalties from the Department of Labor that they can assess imposed under state law Commissioner may assess penalties on an employer not to exceed. So it starts at $100 per violation, per employee, per day, per violation, up to as much as $2,500 for each violation, meaning each youth per day, per violation of the chapter adopted pursuant to that statute. And that money goes to the state. Now, if you're hit with these civil penalty assessments, the Department of Labor rarely reduces those unless you can show there's an arithmetic error, or they've misunderstood what happened, or there was a simple record keeping error that the records were available. And I've had that in a case recently, and they've been produced, but you have to be very, very, very careful in that regard. So what are we focusing on? We're focusing on, again, the types of work, the youth at the age when they are hired and commence work, the paperwork required. Again, my recommendation is the paperwork for those under 16 and those over 16 have to be in place, should be in place before the kid commences work. And then the hours and days of work are strictly complied with. Again, the Department of Labor can jump from $100 per violation to the maximum, depending upon the nature of the violation, the employer's history of violations, and whether or not the employer was acting in good faith or not, which typically is determined by whether or not there's a history of violations there. So my recommendations, as I sort of wrap up this quick review of youth employment laws, is what's my recommendation? Comply with the most applicable standard. And I would say largely that's New Hampshire standards, and that which is typically the stricter standard. Make sure those forms are completely filled out and on file with you as the employer. And when you have to provide copies to our friends at the Department of Labor before the youth commences work, train your managers on timekeeping obligations, the types of work and the hours of work that the kids can work. And I'm a big fan of the color-coded name badges or some other restrictions. So that the manager or supervisor knows that, this color badge, the kid has to stop working at this point, and so on. And my view would be, don't have it go up to the minutes before the maximum. I would say a half an hour to 15 minutes before the maximum for the day, for the week, that there's an absolute hard stop. My recommendation would be a half an hour beforehand to allow a little bit of wiggle room there, because if you're a minute over, you're in violation. And again, the Department of Labor takes that very seriously. And be careful, non-compliance, even minor technical errors can be very expensive, cumulative, very expensive. The margins are thin, and you want to do everything you can to make certain that you've strictly complied with all these issues. Again, the youth is there, the labor market's there. These are willing workers. Going back to my presentation last month, just be careful about discrimination and misconduct, but this focus is on the health and safety and wellness of and the proper requirements for the youth that you're going to be working with this session. Many of you have worked with youth before. This is nothing necessarily new. Just know that the Department of Labor is out more than ever before in assessing civil penalties for violations, and they will be out in force this season. So just be careful. So with that, Samantha, I'm going to turn it back to you for questions.
Awesome. Well, thank you so much for the presentation. If anyone has any questions, you can put them in the Q&A. There's a couple already in here that I'll start with. So the first question is, what classifies as a school week? Saturday through Sunday? Our pay period is Thursday through Wednesday.
School week is Monday through Friday. That is a school week. So you factor in during the school week, Monday through Friday, you have to factor in the maximum number of hours that they can work in that period. Weekends would be different. I understand that your pay period is different, but you have to factor in again, what you want to do is you want to protect the youth during those weeks in which the hours in a particular day in a school week and the maximum number of hours in the school week, because you don't want to interfere with their education.
Awesome. This question might need more clarification, but says some documents say 23 hours and some say 18 hours. Which is it?
Well, the 23 hours comes from no youth under 16. This is RSA 276A:4, and it's Roman 4. And it says no youth under 16 years of age shall be employed or permitted to work earlier than 7 a.m. and later than 9 p.m. no more than 3 hours per day on school days and 23 hours per week on school weeks. That's those under 16. So that's where that comes from. The 18, I think, is on the federal side.
Awesome. Youth employment certificates need to be resubmitted every year. We are a seasonal business with returning employees.
That's a good question, and I'm not 100% certain because I've actually dealt with that recently. And I think if it's the returning youth, I think it's going to depend upon the age. Again, if you had someone that you had the certificates for them and they were under 16, but now they're coming back and they're over 16, it's a different form, obviously. Yeah, my recommendation would be, to the extent you can get them, because again, it's age determined, and understanding how basic biology works, they'll be a year older. I would get a new certificate in place just to be on the safe side as you hire the kids. Unlike an I-9 form, which is, if you rehire someone within a certain period of time, you don't need a new I-9. Youth certificates, my view would be, I'd have the new certificate in place. That might be belt and suspenders and overkill, but still, in this area of the law, no harm in being extra cautious.
Awesome. So weekends count towards a total school week hours. Are you meaning that the total hours, weekends are considered the entire part of the entire week?
Yeah, because it's a non-school day, but it's still a school week. I'm pretty certain that that's the case. You want to check with the friends at the Department of Labor on that one, but I'm pretty certain that that's the case. Because you're still in school, and again, I've got 4 kids and they're out of school at this point, but I do remember that homework was needed and other school activities sometimes on weekends. So yes.
The certificates need to be sent to the NHDOL. What is the best way to accomplish this?
Well, again, that's going to come from the employer to the NHDOL, right? And so you can, I can tell you my experience with the New Hampshire Department of Labor. A lot of our stuff is now online, and we file through, when I do big document productions for the Department of Labor, they have a portal. It's a little bit clunky. You have to notify them in advance that it's being submitted to the portal. So I go old school. I would file a paper form. Now, if you've got a batch of employees who are being hired, you'd send a bundle to them and you send it to the Department of Labor in Concord. And the address where you would send those is on the form, and it's also on the website.
So we have a couple of questions going back to the 18 hours versus 23 hours. Is federal more strict than New Hampshire? Do we need to go with no more than 18 hours per week for under 16? That is the safest course, and I understand the conflict. That is the safest course to use. My view would be, in that regard, to see if it's going to be an issue, because you're rarely going to have a youth employment inspection by the feds in New Hampshire. I would just, you can drop a dime. You just call the inspection division in New Hampshire and ask them for their opinion on that. That's one that to me is a technically, I would say focus on the more protection, the 18 versus the 23, but practically speaking, I think you can go to 23, but I think I would check with the state on that and see what their position is on that. Awesome. Well, does anyone else have any questions before we wrap up? I know we got quite a few here.
My contact information is there too. I'll share that with you in a second. I want to thank my partner, law partner, Andrea Chatfield, for her assistance, and one of our law clerks, Noy Kruvy, with his assistance in putting together some of this information for this presentation. But here's my information. If you have any questions afterwards, you can always reach out to me. I'm happy to help. There's my email and my direct dial. But I want to thank you folks for being a part of this program this morning. I hope that was helpful, and we'll see you next time.
Awesome. And I will, because there were some questions, I will send the slides out. And there will be a recording of this webinar on the NHLRA website. We did get 2 other questions that just came in about push mowers for 14 and 15-year-olds and golf carts for youth under 18.
Okay, so let's do with push mowers. My view is push mowers, because I've dealt with this issue with our friends at the Department of Labor. Unlike the riding mowers, which are absolutely considered to be hazardous, push mower may or may not be. My view would be for 14 and 15-year-olds, I would not having them do push mowers. That's my view. I've had a case with the Department of Labor on that, and they frowned upon that practice. So you'd have someone, I would say 16 or older, doing a push mower. On the golf carts, I don't know the answer to that, because it's driving, but you're not driving on a public road. You're driving a golf cart, presumably it might be on public land or on private land, but you're not on a main road. And I have never seen anything on that with regard to it's motorized, but that's not a prohibition on driving a golf cart. I don't know the answer to that.
All right.
If you, again, there's no harm, no foul in calling the Department of Labor and asking that question of the Inspection Bureau, and they will give you an answer on the phone.
Well, thank you, Jim, again for answering the questions and for the presentation. Thank you, everyone, for joining us, and I'll make sure that those slides and the recordings go out to everyone who participated today.
Thanks so much. Have a great day.
Have a great day.